Good evening, everyone. This is the monthly meeting of the Anne Arundel County Human Relations Commission. The Human Relations Commission is a part of the Anne Arundel County government. It was created for the purpose of promoting and enhancing the ability of all Anne Arundel County residents to pursue their lives free of discrimination. To accomplish this goal, the Human Relations Commission has been charged with the mandate to enforce Anne Arundel County's fair housing law and work towards the elimination of discrimination in Anne Arundel County. If you believe you have been a victim of discrimination in housing or wish to bring some other matter relating to discrimination in Anne Arundel County to the Commission's attention, please contact us using the contact information on the Human Relations Commission webpage on the Anne Arundel County government website. Good evening, everyone. Thank you for joining us for our meeting tonight. It's now 6 o'clock in the evening, and we're going to go ahead and call our meeting to order. Let's go ahead and proceed to our roll call. But actually, before I do that, let me see here. We have a new commissioner, Ms. Lakeisha Hatcher, and I'm looking to see if she is. No, I don't believe she's on the call yet. Hopefully she'll join us shortly. Commissioner Dodoni, Madam Secretary, would you please call the roll just so we can formally note who's on the call tonight?
Certainly. Oluwatosin Bula. Tosin, are you online? Not yet. Commissioner Mark After. Would you mind speaking so we hear your voice? Unmuting and speaking. Oh, waving will do. Thank you. Commissioner Mary Dodoni is present. Commissioner Mohan Grover, if you are present, would you please so signal?
He is not present.
Okay. Commissioner Eugene Peterson, we see you. Could you speak, please?
Present.
Thank you very much. Commissioner Tony Pratt, if you're present, please speak. Not yet. Commissioner Khalid Syed, if you're present, please speak. Not yet. Commissioner Roberto Veloso.
Present.
Seen and talking. Thank you very much. I note the presence of our ex officio member, our Human Relations Officer, Alana Dennis. And our guest speakers.
Okay, great. Let's also note again, we have one.
Faye Gaskin. I'm sorry. Commissioner Gaskin.
Present.
There you are. Thank you so much.
Let's also note, just for the record, we have a new commissioner, Lakeisha Hatcher, but she's not here yet. I think she'll be joining us shortly. Please, if somebody else joins our call and I don't notice it, will you please stop me to make sure we note their presence for the record. But thank you, Commissioner Dodoni, for the roll call. The next item of business is approval of minutes for our meeting on September 17th, 2020. If anyone needs time to review the minutes now, please speak up. Otherwise, I would entertain a motion to adopt them as drafted.
So moved.
Okay. Is there a second?
I second it.
And all in favor? Okay.
Aye.
I just let me stop here for a second. I want to make sure that we have a quorum. And 1, 2, 3, 4, 5. We do have a quorum.
Yes.
Great. All right. Thank you. We're moving right along. Tonight is an evening that's going to be taken up primarily by a number of guest speakers. I want to go ahead and welcome all the guest speakers that are on already. Lori Blair Klasmeyer from the County Attorney's Office, thank you for joining us. And Michael Butzeris, the Executive Director of the Ethics Commission for the County, thank you for joining us. And with that, I think we will go ahead and turn the floor over to you, Lori. Go ahead and please enlighten us. We need all the enlightenment.
I'll do my best. Good evening. I'm Lori Blair Klasmeyer. I'm Deputy County Attorney. And I have been asked to talk to you a little bit about hearing and hearing procedures. Did everyone get the handout that I sent to Alana earlier today? Okay, I won't bother sharing my screen because it's basically, I'm just going to go through that a little bit and then talk a little bit about some rules, potential rulemaking. So I'll just go through this briefly, the Human Relations Commission actually has a very good outline of what happens at a hearing in the code, which is not always the case with some of the other boards and commissions. So you basically can have a hearing about an issue either on your own or in response to a complaint. And if you have a hearing, you can gather facts and make non-binding recommendations to persons or agencies. There are no particular procedures for those hearings, so you can decide how you want to proceed and handle when you do not receive a complaint. I think more typically what you're going to get is you're going to get a complaint that is filed. I know I talked to Kaylee earlier this week, and she indicated that you may have actually gotten, I don't know if you got any formal complaints, but you have had issues that have been referred over to I believe it's the Conflict Resolution Center, and that you haven't had any actual formal complaints where you've had the need for a hearing. I will say that if it occurs that you do need to have a hearing, our office will be glad to provide an attorney to assist you ahead of time and also during the hearing with any procedural or legal issues that may come up during the hearing. So I'm sure Alana or Kaylee will let us know if you need that assistance. So when a complaint is filed, the first thing that happens is the Human Relations Officer reviews that complaint and determines whether it's even sufficient enough to come to the commission itself. If the Human Relations Officer finds that it is not, then that complaint can be dismissed and without any involvement of the commission itself. If the complainant feels that they've been wronged by this dismissal, they can file for reconsideration in writing and by sending a letter to the chair of the commission. The commission itself then reviews the complaint and decides by majority vote if the complaint is sufficient that it may establish discrimination in housing. I do want to say that that is really the only type of complaint that the commission can consider as discrimination in housing pursuant to the code. If it's reinstated, then it proceeds to through the hearing process. If it's not, then it's just considered dismissed. At that time, the Human Relations Officer or any member of the commission can recommend that the parties meet with certain designated members of the commission to discuss a resolution. So this is similar to sending it to the Conflict Resolution Center. And it's one or more members that are designated by the chair. And I will kind of say this is a funky math thing that we may have to think through at some point. It may help with if the rules of procedure ultimately put in place. But the panel that ultimately hears this complaint cannot have participated in this kind of pre-hearing settlement conference. A quorum of your members, you have 11 positions. I'm not sure they're all filled at the moment, but a quorum would be 6 if you had all 11. And a majority of the quorum is what takes action. So if you ultimately hear this, you have to have at least a quorum to hear the matter, and a majority of that quorum can decide the matter. And I'm going to say, I think, because I think ultimately the notion is that, I don't know, I think that's right based on putting the various pieces together. But the commission has to issue the ultimate decision. But I think that because a quorum can act and a majority of the quorum can decide that is correct. So if you're going to do one of these pre-hearing settlement conferences, you have to still have a quorum left to actually hear it. I would recommend that you only have maybe 1 or 2 members, if that, 1 or 2 at most, that would do one of these, unless there's some compelling reason to do one of these kind of settlement conferences. The other issue you get into is if you have too many members do them, you're going to run up against an Open Meetings Act issue.
Lori, can I interrupt you for a second?
Sure.
Do you recommend if we did have a complaint and the human relations officer believed there was a prima facie case of housing discrimination, that we maybe choose a panel, a three-member panel to hear the complaint and basically have them sit out from any of this?
And I know that the code says that you have to have at least 3 members.
Right.
My concern is that's not a quorum. So I don't think that
To have a hearing.
That 3 people alone can have a hearing. I think if you only had 5 members for some reason, in other words, if you were down 6 members, then the 3 might be okay. But I don't know why it says that, quite frankly. But I think that you need a quorum to actually hear a complaint. Only a quorum can, only a majority of the quorum can act. The action is going to be to either sustain the complaint or dismiss it. And therefore, I think you need to keep a quorum at the hearing.
I think then that we need a formal opinion from the Office of Law as to whether we need to change that provision in the code or not.
Yeah, I would, it's something I was trying to piece together that section with the dispute resolution section, with the quorum and action section. And I do think there's some room for improvement, shall we say, in those provisions. And I'm not sure what the intent was to say at least 3. Now, like I say, in a situation where you're down a bunch of members, that might make sense. But in a situation where you have a full commission or a close to full commission, that doesn't work because you need a quorum to actually meet and hear the matter. So.
Yeah, I think we definitely need some clarification on that.
Yeah, because if that's what you wanted, if you wanted a 3-member panel to hear complaints and the 3-member panel to be able to act on behalf of the commission, I think there's another piece there that would need to be in the law. So yeah, I was trying to do the math today and I'm thinking, so in any event, I'll look at that, but right now I think that's, and I will do something formal in writing to that effect. But that's, I think, what the way you would have to proceed at this point.
Okay. All right, very good. Thank you.
And it brings up another, when I talk a little bit about the rules, I'm going to talk about the Board of Appeals because they have a rule that kind of deals with that situation a little bit. But we can talk about what there when I get there. So
may I ask for the purposes of clarification? Request is this what I'm about to say correct? A request has been placed by Chair Veloso that we receive written clarification on interpretation of number of persons needed for each kind of meeting, and it is your intent to provide that to us, and this may or may not lead to a need to amend the legislation.
Correct.
Thank you.
Right, but what remains out of that is that anybody who was on this pre-hearing settlement action can't sit on the panel that ultimately hears the complaint. And again, no matter what we do, if we change the law or whatever, I don't think we want to end up in a situation where you end up with a quorum doing the pre-settlement, because then that's going to become an open meeting. And the issue there is people are not going to be as open if a settlement type discussion is open to, I'm not trying to tell you how to get around the Open Meetings Act, but I think there really is a justification for avoiding a settlement discussion to be an open meeting.
Could we deal with this situation by basically offering the parties to have the matter mediated at the Arundel County Conflict Resolution Center, and then if that doesn't get resolved there, comes back to us for a hearing?
I think that's a good idea. I mean, I think if they can, because then it keeps your entire commission out of it, and whatever happens moving forward procedurally, I think you're in a better position. Okay. And they don't have an open meetings issue like the commission does. So,
and just to let you know, everyone on the meeting here, in actuality, when people do reach out to me, one of the first things I do, if it is possible, is to really try to encourage them to see if they would like to participate in voluntary mediation. I think it's a win-win for everyone. They have input into the outcome and the resolution, and it is a confidential process.
Right. So the hearing date, you choose the hearing date. The parties are advised at least 15 days in advance. The Human Relations Officer can issue subpoenas under Article 1 of the County Code to compel witnesses. And their Article 1 also covers service of those subpoenas. Both.
Lori, may I interrupt you for a quick question, please, if I may? It's Alana. I just wanted, as relates to the subpoenas, are you going to be sending templates to the commission or directly to me?
We can do that.
I
Yep.
don't think
We can even assist you in getting them put together and filled out and
right.
served and that sort of. Yep.
Thank you.
Yep. The complainant and the respondent can call witnesses. They can provide evidence. The Human Relations Officer, they will be under oath. The Human Relations Officer has authority to administer that oath, and you are to consider all relevant evidence. And we can talk about this a little bit more too when I get to the rules part, because there are rules for the Board of Appeals that I've sent a little earlier to Mr. Veloso, which I think are a lot of what's in there is covered here, but there are some things, and that's one of the things what we can talk about in a little more detail. So the complainant has the burden of proof. They have to prove that there has been an incident of discrimination in housing. They have to prove it by a preponderance of the evidence, which basically is more likely than not. So you, as the commission, would determine if it's more likely than not that the housing discrimination has occurred. The hearing is a public hearing. It does have to be open to the public under the Maryland Open Meetings Act. It can be closed if it's permitted by the act. I went through the Open Meetings Act to see what the possible reasons for closing such a meeting would be. There were only two that I think are even close. One would be to protect the privacy or reputation of an individual with respect to a matter that is not related to public business. If somebody came up with some crazy, scary allegation related to their housing discrimination, you may want to close the portion of the meeting where a witness would testify to something that may be private or may be related to someone's reputation or damage their reputation. The other one is to consult with counsel to obtain legal advice. And as I indicated, we will provide an attorney for these hearings. And if you want to talk to your attorney, Board of Appeals does this pretty regularly. They have an attorney that's dedicated to them that they announce. It's not an attorney from our office, it's an outside attorney. And they do close their meetings for periods of time if they need to discuss something with their attorney during a hearing. And one of the things you may want to discuss is if you can close it for some other reason. And so,
what about deliberations?
The Board of Appeals deliberates publicly.
Okay. But is there, I know you're
yeah.
Open Meetings Act than I am, but is there a provision in there that would permit us to deliberate?
I will go back and look. I don't think so.
Okay.
I don't believe there is a separate provision for that. There are some workarounds for that. One is to
and the reason I ask, if we're in a situation where we're having a discussion regarding a witness's credibility,
right.
You know, some folks might feel a little bit uncomfortable basically saying that person's a lying SOB.
right. And maybe that's a reputation of an individual that
right.
And the other thing you could say is that, you know, if your attorney is involved because there are legal questions, then it could be done that way. The other way that is a possibility is, so one of the issues under the Open Meetings Act is that if you're all discussing a matter on an email, that is considered meeting, if everybody's on the email. But there are ways to send emails that don't go to a quorum. And you could have a kind of deliberation discussion. You could deliberate through Zoom in small groups, and ultimately come back to a decision. So as again, not necessarily, I want to tell you how to get around the Open Meetings Act, but I do appreciate, and these are things that the Open Meetings Compliance Board has seen and discussed and said, yeah, it complies. You know, that it may not be in the spirit of the Open Meetings Act, but it certainly is compliant as long as you're not convening a quorum or dealing with a quorum all at the same time. So, so when the time comes, we can certainly discuss how to deal with those issues, because I get it. I mean, it is difficult. It is, and people do show up for the Board of Appeals deliberation meetings. They have it's on the calendar, and people, lawyers that have been involved in cases will go because they hear the decision before the board writes it up and sends it out to them. So, you do get people actually attending those meetings. It does have to be a written decision, including all the findings in fact and conclusions of law. If you find discrimination in housing, you can order cease and desist of discrimination. You can order that the respondent sell or rent the property to the complainant. Or you can, these are all, you can do all of these, or none of them, or one of them. You can find that it's a Class A civil violation under the county code, which is a $10,000 fine. The decision is appealed to the Court of Appeals. I believe it would be a de novo appeal. And then the Board of Appeals decision can
Circuit Court.
No, the first appeal is to the Board of Appeals.
Board of, gotcha. I thought you said Board of Appeals.
Board, I'm sorry, board. I should speak more clearly. Board of Appeals. There is a judicial review after that at the the Circuit Court. That is an on the record appeal from the Board of Appeals. And then the Circuit
Board of Appeals is de novo. You said de novo?
The Board of Appeals, I believe, is de novo. The judicial review in the Circuit Court is on the record before the Board of Appeals. So that's kind of the 10-mile view of the procedures. I tried to outline, put a lot more detail into my outline. And I did understand that you had a real interest in kind of talking about the kind of rules that you would be putting together. I'm glad to see Michael on this call because I was going to reach out to him anyway. I don't know if the Ethics Commission has rules of procedure for its hearing complaint proceedings, but that would be a somewhat of a parallel because they act on complaints. But I also think that maybe their law is a little less detailed than this when dealing with complaints. So certainly, Michael, if he has anything, he can share his rules. I looked at the ones for the Board of Appeals only because they are also an adjudicatory body. Their rules are actually adopted by the county council. So things like they do have fees for filing and that sort of thing, but those are all adopted by the council. And I don't think that this body would have the authority to impose fees without something in the code. So, and they also have staff that are county employees, full-time dedicated staff. So, and I'm sure the fees do not cover in any way, shape, or form those salaries, et cetera. But there is some justification there with the Board of Appeals. So much of their rules, which are in the county code, much of their rules are already kind of incorporated into your into the code for the commission. But there were a couple of things that I did want to
Lori, before we go any further, we have a
I'm sorry.
before we go any further, we have a commissioner that has a question. Commissioner,
I'm sorry.
it's okay.
Yes. I served on the county school board for 10 years, and we had the ability, we had appeals, disciplinary appeals, et cetera, et cetera. We would hear them, and then we would go back into executive session, discuss very freely what had happened, and then we would render our decision. So what role does the executive function play in our deliberations?
So when you say you met in executive session, are you talking about the entire board or just a portion of it?
We would have executive sessions for the entire board prior to the meetings. We would publish minutes on them. I mean, they wouldn't go into everything we said, thank God. But we were very blunt and direct with each other in terms of issues that we were confronted with. And we would also go into back to deliberate. I don't know whether we call it an executive session. We go back to deliberate after we had heard the disciplinary or other complaint, and then we come back and render a decision. Is that possible?
That's what I'm going to look at that a little more closely. I mean, to me, I know that the Board of Appeals, it's an open meeting and they consider it an open meeting. And whenever there's a quorum to transact business, it's supposed to be an open meeting. But I'll take a little bit closer look at that and see if there's some opinions on that or I don't think it's a closed session issue. There may be some other issue, but I'm writing it down just to make sure that.
Lori, for what it's worth, when I've heard hearings in the past for the Annapolis Civil Service Board, we've gone into executive session, and it was my understanding, based on the legal interpretation we had, was that we needed to prepare minutes on the executive session. It wouldn't go into complete detail, but talk about the nature of the deliberations. And then as long as we did that, it was permissible. But again, it's been a while since we've had a hearing over the Civil Service Board for the city.
Yeah, and I was going to say the same thing when I was representing the Maryland Real Estate Commission. Now, I recall for the deliberations, similar to what both Eugene just said and Roberto, that they would have a component of that time where they were deliberating that would be closed, but everything else would be open. So yeah, I don't, maybe it's changed. I'm just wondering.
Yeah, if you're deliberating about like a personnel type matter or sounds to me like maybe some licensure issues and things like that.
Yes.
Yeah, there are some provisions for closing certain, and you're right, even with a closed session, there have to be minutes that go with the closed session. So I'll go back through the list and see if there's something that would apply here that would allow at least the deliberations to be done. I mean, it makes sense, right? I mean, it certainly makes sense. So I will take a look. I've got a note here to take a look at that and let you know.
Thank you, Lori.
No problem.
Have another question from Commissioner Gadoni.
Thank you. You may be addressing this later. I'm going to ask for a lay interpretation of the word hearings. And I ask because in Section 3.5A Alpha 108 Powers and Duties, items 6 and 7 allow for training and seminars, also conducting educational programs without the same sort of constraints that appear elsewhere related to hearings. And I'm particularly curious and eager to hear more about Section 3.5A Alpha 202 hearings without the filing of a complaint. I could use some clarity on that.
Yeah, so the hearings that are referenced, I think, in subtitle 2, which would be the 3.5A-202, really are related to complaints, whether it's whether the commission itself is initiating it or whether it's initiated by a complainant. That's really what's referenced as a hearing. So your training sessions, the other things that you do, those are meetings, but they're not hearings. So it really is a different animal, two different thing. Right now we're having a meeting, right? So if you had a complaint or you were going to discuss a self-initiated complaint, that would be a hearing. Any other questions before we move on to kind of rules you might want to think about? Okay. Like I said, I looked at the ones for the Board of Appeals. I will point out, so they have a rule about minutes. You have to have minutes anyway under both the law in Article 3 as well as Article 1 requires all of the code requires all boards and commissions to maintain minutes, as does the Open Meetings Act. So that kind of gets there's like a triple whammy there on having to do minutes. However, they do have a rule that has a little more detail about some of the things. For example, showing the vote of each member. That would be something that the county council does that as well. And then I'm sure there's a procedure for who maintains your minutes and that sort of thing. That's probably already in place. The one that I wanted to talk about, which kind of gets back to the participation on the hearing board itself, is the Board of Appeals has many hearings that go more than one session. I don't know if you're going to end up having that. It is possible that you would have, if there's enough witnesses, et cetera, you would have meetings that might have more than one session. There are 7 members of the Board of Appeals. You have 11. I don't know how many will actually sit, but even if you're going to have 7 or 8 or 6 or people sit on your hearing panel, the problem is, what if somebody can do one but can't do all of them? So the Board of Appeals has a rule that if the parties agree, a member of the board who attends at least one of the first 2 sessions can, and if there's more than 2, can participate so long as they either watch the video, listen to the recording, or read the minutes of the other proceedings. Then they can participate in the decision making. And I do throw that out there. I don't know how often it's going to come up that I don't know how long. For example, the Board of Appeals in my day, I think they've changed somewhat since the last time I was in front of them. I haven't been in front of them in a while, but they would sit for 2 hours. They didn't care where you were at the end of that 2 hours. That, meeting over, come back in, whenever. So I don't know. You were going to have to decide if you're going to do that, if you're going to have a cutoff at a particular time for a hearing. You'll decide whether you're going to have them during the day or at night, however that is. So that it is a thought that if somebody can make one but can't make the second one, whether you're going to allow them to participate in the ultimate decision. And it may have some bearing on whether you maintain a quorum that can act on that complaint. So that is their rule 1-103 sub D, and I just throw that out there as something to think about. You could get a complicated enough matter that there are multiple witnesses on various sides, and you might have, you don't want to sit for 8 hours. So, you might want to think about a rule that is similar to that, especially in these days of Zoom and recording through Zoom. You're not just reading it off of flat paper. You can see people, you can judge credibility and that sort of thing by watching a video or even listening to an audio recording. So that is a rule that I would definitely think about.
For clarification, you said the Board of Appeals has a rule that addresses that issue?
Yes, it's their rule 1-103 sub D. And it can happen if you only have one meeting. In other words, you can't allow just somebody to come in and but if you have more than one meeting, as long as they make the first one or the second. I mean, the Board of Appeals sometimes has things that go 15 sessions. So, but if you have something that goes 3 and they meet one of the first 2, then they can participate. So, and then parties have to agree to that. And the matter that I had that went about 12 sessions or something, we did agree to that because it's hard to keep an entire quorum panel for all of those kinds of times, but even it can be hard for just a couple of times too. So I throw that out there as a good thing to think about. So like I say, a lot of what's in their rules is covered elsewhere already. I already mentioned that that you can't charge fees, so don't pick that rule. That would have to be done by code. If for some reason you think that you need to charge a fee for something, it's certainly something that could go to the county council with the county executive's blessing. We could take it to the county council. They also have a rule about how they're going to, for example, number complaints that come in, and in what order they're going to hear them. Do they, they hear the oldest one first? So that's a thought if you want to do that. And that gives rise to the question of how you're going to deal if somebody asks for a postponement of their hearing, and how you're going to decide about postponing a hearing. They have a rule about publishing their calendar. I believe this has already happened on your website, but the hearing date should be included on your website calendar. They have a rule that attorneys can appear. I would have thought that went without saying, but if you feel that you want to rule on that, I would find it unusual to say they couldn't. Let's put it that way. I mean, I think in something like this, especially because if you have a rental complaint, you're going to you may have a corporation involved. They're going to need an attorney anyway. Both sides then could have an attorney, but not required.
I think that's something we definitely want to clarify, because someone may want to have somebody who's not an attorney represent their interests. I'm thinking of like a renter, and we might want to clarify whether we want to permit something like that to happen. I could see a situation where an elderly person might want an adult child basically represent their interests, and maybe we want to allow that. Maybe we don't. We shouldn't allow it. Something we should discuss.
Sure. The other thing that they have a rule that you can't file anything other than the complaint. So they don't end up in, basically what we call motions practice of, various things that get filed. But the only thing they allow is a request for a postponement. That's about the only document that you can file a preliminary motion based on jurisdiction, which is, I don't think that's going to be an issue for you, because you're going to have the initial review to even determine if there's a potential claim by the human relations officer. But they also have a rule that says no discovery, which you might just want to throw that out there so people don't try to.
Well, wouldn't that be counter to what is currently in the code, given that the code allows us to issue subpoenas? So, for instance, if one of the parties wanted to obtain certain records, couldn't we issue a subpoena on behalf of that party to obtain certain records?
I think that the subpoena that's contemplated is for witnesses.
Okay.
Yeah, I think that, but I'll double check on that too. I mean, but you're talking about a subpoena for, well, you could subpoena a
witness with
custodian, right? You could subpoena
custodian records, yeah.
Yeah, but what this means is, like, the rental company can't send a set of interrogatories to the, renter. Yeah, no, it would not prevent you from issuing a subpoena if there were certain records you wanted to see.
Yeah, the situation I'm thinking of is a situation where a renter with a complaint might want, who claims that they've been paying their rent on time, request that they produce documentation regarding what rent payments they've received, that sort of stuff.
Right. Or the documentation of who they actually rented to if I'm claiming they discriminated against me and not renting to me. Yeah, something like that. Yep. They do have a rule that you can't have any ex parte communication. So the parties can't contact one of the commission members on the side to talk about something. Again, you would think that would go without saying, but that is a rule. They have a rule that says that the chair basically regulates the course of the hearing and rules on procedural matters. That's probably a good rule to have. And they have a rule basically about, so the Board of Appeals does not operate under formal rules of evidence like we would see in a court. And basically they have a rule that says they will admit any evidence that is probative, and they get to decide whether evidence is probative. They also will accept things that may not make it into court because they aren't properly, what's the word I want? Not, in other words, a court might not let them in because they don't set the right basis for letting them in legally. But they will accept magazine articles. They accept, newspaper articles without really anything other than, oh, here's a newspaper article about this topic. So they do have a rule that it has to be probative and that they will accept it, documents in any form. They have a rule that the parties can cross-examine each other and the witnesses. And they have a rule that they can qualify experts. You may see an expert for all I know. So what I can do is I did send Mr. Veloso a copy of the rules. I'm going to go back through and kind of highlight the ones I think that you want to think about.
That'd be very helpful. Yeah.
Or think about those areas. And like I say, if Michael has something he wants to share rule-wise, maybe they have rules. I'm not 100% sure, never had to go in front of them, thank goodness. I will get that over to you and answer the questions that have been asked. And if there are any other questions, I'll be happy to answer them. I don't want to take up too much of everybody's time, but as I said, can feel free to reach out at any time to ask me questions. If you have a complaint that comes in that's going to go to hearing, we'll be happy to sit down with you again and talk it through from there.
Does anyone have any questions at this point? Okay. Lori, thank you so much for your presentation. Before you go, though, I'd like to stick around for a minute or two while we talk, before Michael begins his presentation on the Ethics Commission. I would like him to provide us any comments you might have or ideas with respect to any rules that might be beneficial for us to possibly consider implementing on a hearing that we will be conducting. Michael, you have the floor, but there you go.
Thank you, Roberto. Hope everyone can hear me. Hi, Lori. How are you?
I'm good.
With regard to complaints, our system, we do have a list of rules and procedures. The ethics law is pretty specific about how we have to handle a complaint. I will say we're a little different because most of our stuff is in closed session because we are dealing with solely personnel issues. We only deal with employees, elected officials, and board members of the county. We do not deal with the public in general. I will say that in my 4 years of being director, I've actually never had to go through an official complaint all the way through a hearing, subpoena, and final decision making. Most of our complaints are resolved informally, usually with settlement agreements, by consensus and by agreement. And that's the way we like to do it. And I'm sure that's the way you're going to want to try to do it as much as possible as well. You get both parties, you talk to them about the issues, you come up with an agreement. They can be put in writing. The agreement becomes public, but the deliberations to get to that point on our side of the fence are mostly in closed session, basically because we're dealing with personnel issues and a lot of private information. But we do have a list of processes and procedures for official hearings and complaints, and I'll be happy, Roberto, to look through those and make copies and send you what I have, and then we can talk about yours. I have not seen the Human Relations Commission law and how you're supposed to deal with them. I know you go through the Board of Appeals. We do not go through the Board of Appeals. We would go straight to the circuit court. Anyone taking an appeal would go straight to the circuit court. But again, I'm happy to share with whatever I have and talk to you about it. So we can do that.
Well, thank you. Appreciate that, Michael. I think with that, Lori, if you need to get going, feel free. But if you'd like to sit in on the rest of the meeting, you're more than welcome.
Believe it or not, I am doing a virtual pub quiz for the Bar Association at 7 o'clock. I have no idea how this is going to work, but I guess I'll be finding out in about 15 minutes. And maybe the law office will bring home the cup again this year. We did a couple years ago. I don't know, but we'll see. So otherwise I'd hang out.
Lori, appreciate your help.
No problem. Thanks.
Michael,
Thank you.
before turning the floor over to you, I just want to acknowledge real quick, we have our newest commissioner to join the commission. Came on board for the meeting a little bit late, Lakeisha Hatcher. Just wanted to say hello. Thank you, Commissioner Hatcher, for joining us. And also, I just want to confirm, Tosin, can you hear us? Can you? We just want to confirm that you can interact with us if need be. I imagine you might be driving in your car, but if you get to a point where it's safe to do so, please let us know, that acknowledge that you can hear us and that you're there. We would appreciate that. And then lastly, I want to acknowledge Robin Dorsey with the Fair Housing Action Center of Maryland, who's here. And she's going to go ahead and speak with us after Michael. But with that, let me go ahead and turn the floor over to Michael. Michael, thank you for coming to speak to us about the ethics law and the ethics commission. And the floor is yours.
Thank you, Roberto. Thank you, commission members, for inviting me. I'm going to try to share a screen here, Roberto. I don't know if you have video turned on or not.
Hold on a second.
But optimize screen for video sharing, share sound computer. Okay, let me try to pull this up.
I think you should be able to do it. Give it a shot. And let's see if we can make it work. Are you getting any messages on your end?
Let me see here. Let me try to share that. Let me put the, okay.
There we go.
Let me put this in present mode. Okay. Can you all see that, Roberto?
Yes.
Okay, great. Of course, I can't see anyone now, so I'll just assume you can see that, not me. But either way, let me talk briefly. For those that don't know me, my name is Michael Botsaris. I'm the executive director of the Ethics Commission. I've been the executive director since 2016. Prior to that, I was a Ethics Commission member for a little while. And prior to that, I was a Maryland attorney for, and still am, for the last 33 years. So with that being said, let me just give you a brief purpose of the ethics law. The ethics law establishes minimum standards of conduct to ensure that the decisions of county employees, elected officials, and commission members are made impartially and with independent judgment and without improper influence, or even the appearance of improper influence. And I think that's an important part of the ethics code. And if you look at the legislative history and the preamble of our code, which can be found in Article 7, it specifically mentions the appearance of improper influence. So although there may not be a technical improper influence issue, if it smells bad, looks bad, and it tastes bad, it could be a violation of the ethics code. So you have to remember that even if it's not a violation in accordance with the four corners of the code, if it appears to be and it looks like a problem, the commission can very well consider it to be a problem. And for that, my next slide, I want to just show you a brief little video about why ethics in government is so important. Hopefully you can see this.
I think we need that 5G.
Yeah, I'm going to skip through that video. It's a brief video. It just kind of highlighted the problems that our mayor of Baltimore City had, and highlights that those problems started as ethical issues. They were failure to disclose, and if there were proper disclosures, a lot of the actions that later turned into criminal issues for Ms. Pugh could have been handled appropriately prior to the federal authorities getting involved and prior to her tragically having to spend time in a federal prison. So ethics issues are important. They're important for many reasons. And one of the most important is disclosure. If you don't have disclosure from elected officials and from board members and from certain employees, then it's very difficult to maintain the ethics code. So the Ethics Commission is made up of 7 citizens of Anne Arundel County. And for those of you that have already taken the ethics course, this will just be a way of review. And hopefully if you have any questions, I'm happy to answer them at this time. This is not intended to be an educational session. It doesn't satisfy the requirement, unfortunately, but most of you have taken it already, and I appreciate that. But I'm more than happy to answer questions, so interrupt me as I go along here. But the commission is appointed by the county executive with approval of the county council. The commission has certain guidelines. They can't be government employees. They can't participate in the campaign of any public office. They no more than 4 of the commission members can be of the same political party, and it's up to the commission to appoint and to hire an executive director, and that's me. And we have one secretary, Gina, who many of you have interacted with, and she's been there longer than I have and knows probably more about the Anne Arundel County Ethics Commission and the laws than I do. But she's a good person to reach out to if you have any technical questions or procedural questions about our office. So the duties of the commission, as I said, Code Article 7 of the Anne Arundel County Code lists the law, the ethics code. It's a rather legalese document. It's 10 or 12 pages long. It's not something you want to read for the fun of it. It requires much interpretation, and it's the duty of the commission, with my help, to administer that section of the law. We are also responsible for maintaining financial disclosure statements and conflict of interest statements. Many of you have already filed financial disclosure statements as required by law. Those are kept on file. They are made available to the public if anyone asks. If someone does ask, we are required to tell you who asked and when. Fortunately, we have very little requests from the public except for a few elected officials and usually during election time. Other than that, we have very little requests for disclosure of financial disclosure documents. But we do review every one. That's part of my job, is to look at every single financial disclosure statement, to, if I see anything questionable on there, to get back to the employee or the public official and follow up and ask any questions, just so we avoid any ethics issues down the line. That's what we're trying to do. We like to catch things before they turn into serious ethical procedures. We're also required to maintain lobby registrations of lobbyists. We've got about 85 lobbyists in Anne Arundel County, and they're required to file registration statements yearly. They're also required to file biannual reports. They have to list if they've given any gifts to employees, if they spent any money, if they've offered any trips. So we keep a pretty close eye on the lobbyists, and that's part of our responsibility as well. And then we do the ethics training. I instituted the online training system last year, and we were just starting to unroll it when the pandemic hit, so everything kind of got shuffled around a little bit. All employees have not taken it yet. We're working department by department trying to get that done. We're trying to get most of the boards and commissions on board, especially the new boards and commissions, and have them do it before they start conducting much business. So again, thank you all for participating in that. The other important job of the Ethics Commission is issuing advisory opinions and informal advice. And I'll talk more about that a little bit later. And then we also, as we talked about briefly, we review complaints. We investigate complaints. We have similar subpoena powers, similar hearing powers. We also have the right to bring our own complaints, which I think you do as well. If we see something in the press, or if we get a anonymous tip that we investigate further and we decide to bring our own complaint, we have the option to do that. Um, and we also have the option to conduct hearings, and we're required by law to make findings of facts and conclusions of law if there is a formal hearing process and a formal decision made by the Ethics Commission. Like I said to Lori, since I've been here, all of our complaints or issues that have arisen have been resolved by settlement agreement or a simple letter or dismissal of the complaint with an agreement. So, and we try to do that. There's no reason to go through the entire hearing process unless someone is being obstinate, unless they fail to recognize what the ethics violation was or fail to take responsibility for it. And then I think we would be forced to do it. And we're more than prepared and willing to do that. Just thank goodness we haven't really had to do that in the last 4 years. Then we do have the power to issue orders of compliance, reprimand, and we can issue other enforcement procedures authorized by our law. Um, so conflicts of interest, that's the basis of our law. There are 6 different conflict of interest situations that are covered by the Anne Arundel County Ethics Code. What is a conflict of interest? Well, generally it's a situation where the concerns or aims of 2 parties are incompatible, or where a person is in a position to derive personal benefit from actions or decisions made in their official capacity. Now, that's a broad sort of overview of when a conflict of interest may come into play. Like I said, there are 6 different ones that are addressed in the code by different sections. They involve participation, when you can and cannot participate. They involve secondary employment opportunities, when you can and cannot be employed by certain other employers at the same time that you're employed by the county. There are representation issues where county employees are not allowed to represent other persons in front of other county officials. And we'll talk about that a little more since it's changed recently. And there's also the obvious gift restrictions and prohibitions, and then the very broad prestige of office provision, which covers many, many different types of employee activities. And we'll highlight a few when we get there. And then disclosure or use of confidential information. That's also considered to be a conflict of interest and prohibited under the ethics law. Can everyone still hear me okay?
Yes.
Okay, good. So I can't see anyone. I'm just looking at my screen here. Participation. That's the first one. That's a very broad section of the code. And it basically says that a county official or public official, and that it does include board members. Board members are considered employees under the ethics code. They may not participate in any matter where they or a qualifying relative of theirs has an interest that might be different from the general public. Another way to say it, or another way to look at that, is they cannot participate in matters involving other persons or business entities where the employee or official or qualifying relative of the employee or official has a financial, employment, contractual, creditor, or potential employment interest. When we talk about qualifying relatives, we're talking about a spouse, parent, child, brother, or sister, and we're very specific about that, and that's what the law says is a qualifying relative. So if it's a cousin or an uncle or an aunt, they would not be considered qualifying relative. And if they had an interest that was different than the general public's that may be affected by a decision you're making, they technically would not be included under this law. However, we got to get back to the question of appearance. If there is an appearance, if there is some direct relationship, if there is some direct benefit to someone who may not be a qualifying relative that you are somehow associated with, there could still be a violation under the ethics code. But technically, a qualifying relative is a spouse, parent, child, brother, or sister. Examples, and I put some examples here with regard to board and commission members. Board and commission members deciding matters where you or a qualified relative of yours or a business you're involved in has an interest that could be affected by your findings, decisions, or recommendations. Now, that should go without saying that if you have an incident come up that requires decision making from your commission and a particular board or commission member has a interest in that other than or different than the general public, in other words, they have some relationship with that person or some relationship with that business or property owner outside of their official duties, then they should recuse themselves. And that's the remedy for participation. Doesn't mean you have to resign from the board, doesn't mean you sit there and listen but don't take any actions. It means you recuse yourself. And what that means is you let the chair of the commission know that you have a potential conflict. You may or may not, or you do or do not have to tell them what that potential conflict is, but you do have the duty to recuse yourself. And by recusing yourself, you don't participate in any function of that particular hearing or issue until it's completed and finalized. So recusal is an important remedy that you should not hesitate to use if there's any questions. And again, if you have any questions or issues, come to the Ethics Commission with a request. Ask the question beforehand, not after. The Ethics Commission does have authority under law to grant certain exceptions for participation issues or recusal issues that may arise in your duties. And we encourage you that if you have any question about it, to send us an email, pick up the phone, or make a formal request for an opinion. And we're more than happy to do that. That's why we're here. Second conflict is secondary employment. That involves board and commission members a little differently, since you're not an employee, you're not being paid by the county as an employee, but you are still considered a county employee. So when it talks about doing business with your employee's agency or commission, those things would still be in effect. So you should not, in your position as a commissioner, accept any position or secondary employment with a business that does business with your commission or agency. They can do business with the county, that may not be a problem, but this law talks specifically about such an entity doing business with your commission. Or if the business or entity is regulated by your commission, or has a contract with your commission, or is a subcontractor on a contract with your commission, then you need to avoid becoming an employee of that particular organization.
Michael,
Now, there is an exception for board and commission members. It's an important one, and you all probably filled out a form when you before you were appointed to the commission, and it's a conflict of interest form. And the exception says that if you were employed by such an entity prior to you becoming a board or commission member, or prior to being considered for appointment, as long as you disclose that information to the appointing authority, and that would be either the county executive or the county council or both, as long as you disclose what your potential conflict is in your employment situation, then that appointment authority has the duty and responsibility to review that potential conflict, and then they can still appoint you. And if they do that and it's disclosed, then that particular employment relationship would be exempt. Again, generally would be exempt. If a certain situation arose in your position as a commission member that would be specific to you and or your employer, where you would have a conflict, where your employer would have an interest in the outcome, then you would still be subject to the participation rules that we discussed previously, as well as the secondary employment rules. But anything that you were involved in prior to being on the board and disclosed to the appointing authority, then you would be exempt from those types of conflicts.
Michael,
Again,
quick question.
Yep.
Would someone who works for a property management company be prohibited from sitting on the commission as a commissioner, or could they simply sit on the commission and if an issue came up with their employer, they would recuse themselves from the case? I hate from the
Yeah, that would be a participation issue. Um, where as long as that property manager is not hearing a case involving their property or their tenant or their owner, then then there would be no restriction on that. And again, that general conflict of being a property management person would have been disclosed in uh, the preliminary conflict of interest disclosure form to the appointing authority. So everyone would know about that position and everyone would know that there's the potential for a conflict if a situation arose where that particular property owner had an interest different than the general public in that particular case. And then you would get back to the participation issues of recusing yourself. But there's not a general broad ban on categories of employment because there may be potential for conflict.
Thank you.
I'm just going to highlight a few of these examples. For board and commission members, generally should not be employed by a business or organization that the board or commission regulates or oversees. Again, getting back to the property owner situation that was brought up, as long as it was disclosed in the pre-appointment conflict of interest disclosure form, the general conflict there would be exempt, but you would still have to look at the specific situation if one arose. Um, Other things are more geared towards employees, such as a fire department officer cannot accept employment with a vendor that sells fire equipment. A county construction inspector should not work for a developer that does business in the county. These are all cases that actually we've decided, so that's why they're up here. Local health department employees should not be working for medical companies that sell medical supplies to that employee's department. Those are all specific examples of secondary employment ethics prohibitions that would be a problem and would be considered a conflict of interest. All right, number 3, representing others. This is one, I think, Roberto, that we've had a lot of discussion about.
Indeed.
And we've changed the law again to try to ease the burden on board and commission members. The law generally says that an employee or county official or a board or commission member, since they are employees, cannot assist or represent any other party other than the county in any specific matter before any county agency or department or other county employee where the county has an interest. Now, this particular section of the code caused problems a long time ago before, Roberto, you were involved, before I was involved, back in 2012, and the county council decided that the easiest thing to do was simply to remove board and commission members from the definition of employee, and therefore they wouldn't be barred by any of these restrictions. And they did that to the opposition and disapproval of the county ethics commission at the time, and to many other people, but the board member or commission member at the time had enough clout to have the county council change the law to the fact to just remove them completely. And the result of that was that no board or commission member was ever subject to the county ethics code. So they never had the participation issues to worry about. They never had the secondary employment issues to worry about. Our commission could not look at any behavior of the board or commission member to see if they were engaging in any serious conflict of interest matter. And that became a problem. The second problem was that they didn't change the law with regard to financial disclosure statements. So all of the board and commission members back then still had to file financial disclosure statements, but the commission was put in the uncanny position of not being able to review those financial disclosure statements because those persons were no longer employees. So they only changed one part of the law, didn't take out the disclosure section. And so when we got financial disclosure statements from board and commission members, we just kind of put them aside, didn't look at them, and didn't take any action with them, which it's fair to say is not good policy. So we put that back in a couple of years ago. My recommendation, it was when Steve Shue was county executive, and we put the board and commission members back into the definition of employee for purpose of the ethics law. And it worked fine until we had a situation where um, we have board and commission members who, as part of their livelihood and duties, are representing people in front of counties, agencies, or departments. And that became such a problem that it rose to the level that we decided to um, carve an exception out in this particular rule. And we did it after looking at the state law because we didn't realize that the state law had actually dealt with this issue a little differently. And we sort of copied the state law. And we said that as far as the rule against representing others, with regard to board and commission members, it did not apply or does not apply now. Um, as of July of this year, it does not apply to board and commission members who represent such parties unless payment for that representation is contingent on the outcome or results. So the only restriction now with regard to board and commission members representing other folks in the county or in front of county agencies is that you can't do it for contingent representation, meaning you can't be paid based on the outcome of your representation, whether you win or lose, whether you're successful or unsuccessful. If your compensation is tied to that somehow, then you still have an issue and a problem. As long as it's not tied to that, then you no longer have a problem under this rule. However, you still have to look at the other ones, the other participation issues where you may have a direct interest or qualifying relative of yours may have a direct interest. They all still could be relevant. So it's not a compart a blanche exception that would apply to any representation situation. It just allows a carve out in this particular section of the code to allow you to represent persons in front of the county. Um, and it's usually when your livelihood, normal course of business is to do that. These aren't usually individual cases where something comes up on one particular situation. It usually involves attorneys or accountants or someone who makes it a part of their practice to deal with the county. So that's now part of this representing another code section and applies to board and commission members. And fortunately for Roberto, it allowed him to come back, or made him comfortable enough to come back on this commission, which was the desire of everyone involved. So Roberto, thanks for your help in getting this passed.
Sure, absolutely.
Examples of representing others. Again, most of these apply to actual employees. Employees should not be representing other persons or family members in front of other county agencies at all. If they're not a board and commission member, there is no exemption for contingent or non-contingent representation. They're not allowed to do it at all. And we strictly enforce that rule. We can't have county employees standing in front of other county employees representing third parties. And that's the reason for this particular section. For gifts, this one's always gets a lot of controversy, especially around Christmas time, but it's a very technical law. It has a lot of pieces and parts. The first part that you have to understand is what a gift is. And a gift is defined in the code as the transfer of anything of economic value, regardless of its form, without adequate and lawful consideration. So that's kind of the legal definition of a gift. Most attorneys would recognize that as a legal definition. Most other folks may think it's about a complicated and confusing definition, but that's gift. It doesn't have to be a physical product given from one person to another. It can be anything of economic value. what does the code say? It says that employees and county officials and commission members are not allowed to accept gifts from controlled donors. And that begs the question, what is a controlled donor? And then we get back to the legal definition of a controlled donor. It's specifically spelled out in the code as a person or entity that does or seeks to do business with the county or engages in an activity regulated by the county or has a financial interest that may be affected in a manner distinguishable from the public generally by the official's duties or is a lobbyist with respect to matters within the jurisdiction of the employee. So basically, a controlled donor is a person who has some business or dealings with the county or your agency or commission and has some uh, ongoing relationship with the county. Um, that's the restriction on gifts. Now, it says it very broadly, very specifically. The county employees cannot accept gifts. And then it goes into the exceptions. And the exceptions here are kind of the rule because there are a lot of them. So the exceptions to the prohibition of gifts is one, if the gift is worth $20 or less. So if one of those controlled donors gives you a gift that's valued at $20 or less, the commission or the ethics code considers that a nominal gift that's not going to influence your decision making, and that's allowed. The other exception is occasional meals and beverages valued at $25 or less, with the specification that they have to be consumed in the presence of the donor. So, if someone gives you a gift card or a restaurant gift card that's valued at $25 or more, then unless they're going to dinner with you, it would be a problem. But if they want to take you to dinner and it's valued at $25 or less, and they're there at the time that they pay it, and you're there, then under the law, that's considered an exception and allowed gift. Uh, Reasonable travel expenses. This applies to elected officials and department heads where they're often invited to attend conferences or events. Uh, Sometimes these conferences or events turn out to be just big vacations. So the ethics law is very specific that you're not allowed to accept those expenses as a gift unless you are participating in some significant way at the event as a speaking person or on a panel or some other contribution to the event, not just attending, not just sitting in the audience taking notes, not just playing golf, going to dinner, going to the show, going to the clubs. You have to actually be a participant on some panel or speaking at the event in order for the ethics law to exempt you from the gift restriction on that. And that's only if someone's is offering to pay your way, which is often the case. You have a vendor who wants to pay your way to a conference. The conference is in Las Vegas. You get complimentary tickets to a show, play golf, go to dinner. Um, that's all prohibited unless you're actually participating at the event. You're on a speaking assignment at the event, you're on a panel. I would say that you are on some sort of agenda that can be shown or proven. Um, and we do have a couple times a year people question us about those events. And um, the other exemption or exception is gifts from family members. It's hard to restrict gifts from family members under the ethics law, even if it's more than $20, um, especially holiday time, birthday time. So it's not what the ethics law is intended to do. You could still be in violation if you are seen as, if there's an appearance of an undue influence, if you're participating in a manner that may involve that family member, especially when it's a qualifying relative, like we talked about previously, and they have an interest. But the general rule of not accepting a gift from them is not applicable. Elected employees have another exception that they use fairly regularly, and that is they're allowed to accept free admission to a charitable, cultural, or political event if it is from the sponsor of the event. Now, we get lots of questions from county elected officials about this rule. That does not mean a Ravens game. It does not mean an Orioles game. You know, Whether it means a Baltimore Symphony, well, that could be cultural. So there's a lot of issues where the Ethics Commission, and they can change as ethics commissions change on what is a cultural or political event, um, and who is the sponsor of the event. So there can be some gray areas there, but the important thing is just to know that uh, the law is there and that the exception is there, and that if you have any doubt whatsoever, that the question should be asked of the Ethics Commission before you attend the event, not after. Um, and then you get to the exception to the exceptions, which makes it even more complicated. And that says that even if one of the exceptions above applies, which we talked about all those exceptions, even if those would be relevant, they're still not permitted if the gift would tend to impair the impartiality or independent judgment of the employee or commission member, or the gift would give the appearance of impairing the impartiality and independent judgment of the commission member. Again, we get back to that notion of appearance, which is oh so important in the ethics law. So don't forget that. If it's a technical exception, the gift is $20 or less, no big deal. But if they're giving it to you right before a hearing, then maybe it is a big deal. If they want to take you to dinner and it's $25 or less and they're going to sit there and eat it with you, maybe it's an exception. But if they're doing that right before you're ready to make a decision on an interest that they have, then maybe there is a problem. So you just have to be aware that the appearance aspect is always going to prop up in the ethics code. I'm not going to go through these examples of prohibited gifts. You probably read most of these when you took the training. I think we hit gifts enough to know that there are exceptions and then the exception to the exception. So just be aware of that. Prestige of office. This is a very broad conflict provision. And it has a very simple statement that an employee or county official or commission member may not intentionally use the prestige of their office or public position for their private gain or the gain of another. So that one sentence encompasses an awful lot. It means that you cannot use your county title, cannot use your county position as a decision maker or as a regulator for your private gain or the gain of another. Where we most often see this come into play is using your official title or position on something unrelated to the county. So if you are a lawyer or a accountant and you put on your business card your name and you put underneath of it commission member, Human Relations Commission, Anne Arundel County, that would be a violation. You're using your county or your title position for your own private gain. So you shouldn't put it on your private business cards. You shouldn't put your title on a brochure. You shouldn't send a letter under your signature noting your official title for a private matter that's not related to your county position. Another issue that comes up with prestige of office is using county resources. You cannot use county time. This applies more to employees than commission members because you're giving your time freely. So it's not relevant for most commission members, but for employees it is. If you're taking time out of your day, if you're an employee to do some private work, that would be considered a violation of prestige of office position. If you're using county supplies, if you're using the county copier or county equipment to conduct any further business of yours privately or personally, especially political activity, if it's not related to your county position, then it should not be done using county resources, and that's considered a prestige of office violation. Giving a referral or recommendation. We have that issue a lot with county council people, county executives. They want to recommend people to certain other either jobs or schools or or another entity. Um, and the general rule is that you should not be using your title or position when you're giving a referral to someone outside of the county. Now, it doesn't apply if you're giving a recommendation within the county. So if you're recommending someone that works with you in your county position that you have personal knowledge of, and you're recommending them for a position inside the county, then this doesn't apply. But the general rule is you shouldn't be using your title or position to benefit another by writing a recommendation using that title or position. Um, and finally, it ties back in with the gift law from non-controlled donors. If someone gives you a gift and they're not the controlled donors, and the most obvious example of that is a county, trash collector or a county Department of Public Works employee. If they're given a significant gift by a citizen, just because of their county position or because you're doing your county job, that could be considered a prestige of office violation. Now, we get a lot of that. The commission's opinion has been that if it's a nominal gift, we're going to consider it an exception. We're only looking at large gifts that would tend to influence what you do in your position or influence how you would do your job. So that's the prestige of office position. Again, uh, one little sentence that means an awful lot. And there's also an exception for elected officials who provide customary constituent services. And right now we're dealing with the county council. I'm trying to come up with a definition for what is customary constituent services. And that's a difficult one because it's not defined under state law, it's not defined under county law. And we've got 27 years of ethics opinions that deal with customary constituent services. So it's not something that's easily defined, but that only applies to elected officials who have constituents and not necessarily the board of commission members. The final potential conflict of interest is confidential information. In your position as a board or commission member, you are going to come into possession of information that is confidential, that is personal in nature. And it is important, not just from a legal standpoint, but from an ethical standpoint, that you not disclose or use that information for any personal economic benefit or the benefit of another. And the code specifically prohibits you from using information that you gained while in your county position from personally benefiting another person or yourself. And we have a couple examples there. Most relevant one would be where a commission member uses information that you would obtain through a confidential commission activity or hearing to economically benefit yourself or to benefit another person or business. So you just have to be careful. And not just ethical wise, you could also be subject to civil and possibly criminal penalties as well. But confidential information is the sixth and final conflict of interest that's defined by our code. And as a last note, I just want to let everyone know that actually that's not the last one. This is a special exceptions for board and commission members. The ethics code allows the ethics commission to exempt commission and board members from the ethics law if certain situations arise, and they're very specific, and there's 3 of them listed. And I can tell you in my 5 years of dealing with the ethics commission, I haven't seen this put into place at all. But if there's an unreasonable invasion of privacy, the ethics commission may exempt a commission member from a particular conflict situation. If it reduces the number of qualified candidates, in other words, if the county council or county executive cannot fill a position because of a particular conflict, then the commission has the right to exempt that person or that conflict. And if the commission feels that it's not necessary to preserve the purpose of the ethics law, then the commission also has the ability to exempt a commissioner board member from a provision of the ethics law. So if you have any situation that comes up where you think one of those does apply and you want to make a request to the commission to exempt yourself from the ethics code or a particular conflict provision, then you need to do that in writing. It has to be sent to the Ethics Commission, and it can also be made or will be made available to the public. So anyone that may request it down the road would have access to it. But again, this is something I've not seen in the 5 years that I've been dealing with the ethics code. All right. Finally, request for advice. As an employee, as a commission member, as a board member, you have the absolute right to request a formal advisory opinion or informal advice from the commission about any ethics question that you may have. And that's why we're here. That's the function. And we spend 80% of our day doing exactly that, whether it's an informal email, whether it's a simple telephone call, whether it's a formal written request, where we are obligated to respond within a certain amount of time in writing. You have the right to ask for that information, and we encourage you to do that. That's why we're here. It's important to do that before you get into a situation where an ethics violation may have occurred, before someone else decides to file a complaint against you, before someone in the media decides to write an article about you. It's important to do it ahead of time. And that's the reason why we do the training. It's the reason why I'm happy to talk to anyone about any of the conflict of interest provisions. Is if you ask ahead of time, it will be difficult for the commission to go back and find a finding of an ethics violation when they've given you an opinion otherwise. So very important. It is your legal right and obligation to do. This year, or in the recent code change, we also added the informal advice as an actual legal requirement or a legal section. It was done all the time before that, but there was never a formal section in the code that allowed for that. Now there is a formal section in the code that does allow for our commission to give informal advice. That information is kept confidential, and everyone on the board commission has the right to do it. The other thing with advisory opinions, they are made public. We do publish them on our website. There is a search engine in our website that allows you to search. If you want to search procedure of office, you'll come up with every opinion that we've decided to issue a procedure of office. What we try to do is, before we publish those to the web or make them public, we try to redact any identifying information. So if it's a particular county council person or board member, we won't give that person's name. We may say county council person, we may say board or commission member. If it involves a particular business or entity, we may not give that identifying information. The code does require us to redact any personal information to the extent possible, and we try to do that. There's no reason to have everyone's personal ethics issues out there on the web or public, when what you really need to know is just the reason for this decision and the basis for the facts and the decision being made. So with that being said, that's all I have, Roberto. I'm more than happy to take questions now, or anyone is invited to give me a call at the office or an email anytime, and we'll be happy to respond. So thank you for allowing me to talk to your commission.
Thank you, Michael. Really appreciate you taking the time to talk to us about this, the ethics law. It's an important law that we need to be well aware of. Anybody have any questions for Michael? Okay, I think we know how to get in touch with you, and if something should come up, we will definitely do that. Really appreciate it, and also would appreciate if you send me a copy of your procedural rules in case we want to borrow some of them for our own hearings in the future.
Yep, certainly happy to do that, Roberto. Thank you all.
Okay, thank you so much, Michael. You have a good evening. Thanks again.
All right, good.
All right, thank you. All right, thank you everybody for being here tonight. We have one more special guest, Miss Robin Dorsey. Robin, very nice to meet you. You are on mute. You need to hit the mute button, and I think you'll be able to.
Hello, welcome. How are you all doing tonight?
Good, thank you. Thank you for joining us. So
Yes.
Just let me give a very brief introduction. As I understand it, Robin, you're the director of the Fair Housing Action Center of Maryland. Is that correct?
Almost. I'm the Fair Housing Director at the Fair Housing Action Center of Maryland.
Gotcha.
We have two directors at our organization.
Okay. Well, again, we are all ears. Let's turn over the floor to you. Please go ahead and share with us.
Well, thank you so much. And thank you, Ms. Fay, for inviting me to present tonight. I'm really excited to be here talking to y'all. I understand you have some big exciting plans ahead as you're developing your enforcement capacity. And I am excited because I'm on the exact same journey. Before I get started though, I want to encourage all of you to stand up and stretch. You have been sitting here staring at this computer screen for 95 minutes now, and I know you're tired. Zoom meetings are brutal, so please move a little bit, shake it out. There you go. Get nice and refreshed, and I will get my screen sharing going on.
Yeah, you should be able to. Yep, there we go.
So, as Roberto said, I am Robin Dorsey. I am the Fair Housing Director for the Fair Housing Action Center of Maryland. I'm going to call that FHAC because otherwise this presentation will take twice as long. I'm actually going to use a lot of acronyms tonight. So if you catch me using an acronym that I haven't defined, please just like wave at me and I will try to remember to go back and define them. So I'm at the Fair Housing Action Center of Maryland, or FHAC, and we work to ensure that every Marylander has access to safe, affordable housing, free from discrimination, harassment, and code violations. And FHAC is a program of the Maryland Consumer Rights Coalition, or MCRC. And MCRC advances economic justice and financial inclusion through direct service, research, organizing, education, and advocacy. We are a brand new fair housing tenants' rights organization, but I like to think of us as the phoenix rising from the ashes. Some of you may remember Baltimore Neighborhoods, Inc., or BNI, which was the statewide fair housing organization in Maryland for about 5 decades. And they unfortunately closed their door in 2018, and several housing advocates came together and said, this cannot stand. Fair housing is too important. We need there to be a strong fair housing organization across the state. And so FHAC was born, and we are sort of being fostered by MCRC. We're on our way to being adopted into the program entirely. So that's where we come from. And not only is FHAC a new fair housing organization, I am new to fair housing. I am even newer to FHAC. So I started on July 1. So I am still very much in my learning phase about how the enforcement process works. And so putting together this presentation was sort of felt like a final exam for me during my self-orientation stage. So feel free to hit me with all of your questions. I may or may not know the answer, but I will always be happy to go back and find it when I don't. And I should have clicked through. That slide was for the one where I was talking about the 2 different organizations. So there's our acronyms nice and clear. Quickly, I'm going to talk about the 2 programs that FHAC has. I'm going to spend a very little bit of time on our tenants' rights program and then a lot of time on our fair housing program. So the tenants' rights program empowers tenants to advocate for themselves by providing information about their housing rights and their responsibilities, connecting them to legal resources, legal information. We do some mediation, although you guys have a great mediation group in Arundel County. We also do referrals to nonprofits and legal assistance groups. And we cover sort of all of those issues you see on the right side of your screen. That's what we work on. And probably others that aren't included in that list. But if it comes across your mind, if you have a housing question, we are happy to work with you to find an answer. So fair housing laws are complex. You guys have already gotten into that a little bit tonight, I'm sure. I'm really trying to take a step back. I think you guys have gotten into the nitty-gritty of the complaint process. It sounds like I caught some of the presentation earlier during bedtime. I'm going to zoom out a little bit and look at how the different laws at the federal, state, and local level work together, who enforces what, and then what the state of fair housing is nationally and in Maryland. So basically, fair housing laws ban housing discrimination. Any attempt to limit where someone can live, any attempt to limit the free and fair housing choice is the phrase, based on membership in a protected class. That is a very broad thing that fair housing laws outlaw. I have 3 slides that go through all of the specific things that includes. I'm not going to read through them. I'm going to send you guys this presentation so you can look through it later at your leisure if you want.
That would be great. Thank you.
Yeah, so basically it's anything that is any way that you treat someone differently based on who they are in terms of housing is going to be covered as housing discrimination. That's sort of the really big view. That can include so many things. Mortgages, real estate agents, landlords, property managers, but also Zillow. Anywhere that you advertise housing or rentals, they are held accountable to fair housing regulations as well. So Zillow, the Baltimore Sun, Craigslist, those are all covered entities. They all publish housing ads. They are all also part of this. And another one I want to flag is this second to bottom bullet point here, that threatening, coercing, or intimidating somebody in connection with them exercising their fair housing rights, that is also a Fair Housing Act violation. So it's not just the discrimination itself; it's also interfering with the attempt to exercise fair housing rights, which we'll come back to a little bit later. That's more or less a comprehensive list of all the things you cannot do because of fair housing laws based on membership in protected classes. So what are the protected classes? Each level builds on itself. The federal law lays this is the ground floor of who we protect. Maryland adds some additional protected classes in their law. The things that are in blue are unique or are above and beyond what the federal level does. And then you see on the far right, Anne Arundel County, you guys have even more protected classes than the state of Maryland. So at the federal level, there's 7. State of Maryland has 11. Anne Arundel County, you guys have 16 protected classes. The difference between what you guys protect and what Maryland protects, that means that you guys exclusively are the ones who are enforcing that part of the law. When there's overlapping protections, when it's Maryland law protects somebody and federal law protects somebody, then you've got enforcement backup coming at the state level and at the federal level. But the laws, the protected classes that are just Anne Arundel County, that's going to be solely the enforcement responsibility of the Human Rights Commission, or Human Relations Commission, sorry. Those are the purple ones on under Anne Arundel. There are also some exemptions at each level of the law. The federal law, the big one is owner-occupied buildings with no more than 4 units. I think this is commonly referred to as the Mrs. Murphy exemption, which is envisioning a elderly widowed woman who has subdivided her much too large home into small apartments and is not held, is able to pick her roommates, pick her boarders. Fair housing laws also don't apply if you're only selling one home without any professional assistance and you're not advertising it at all. The advertising always has to be in compliance with fair housing laws. But if a friend wants to sell me a house and we do it just between ourselves, that transaction is outside of the law. Private clubs, religious organizations, those are also exempt. Maryland has a really similar exemptions, but we do it with 5 units for the Ms. Murphy exemption instead of the 4 units. And then really interestingly, Anne Arundel County, you guys have almost no exemptions. You have no Mrs. Murphy exemption, just age-based protections to make sure that that protected class of age that you uniquely have isn't stopping, forcing younger people into nursing homes. Like nursing homes are exempt from that, daycare type places are exempt from that. And then you have private clubs, religious organizations, and a protection for veteran housing in there, that veteran housing, veterans can get sort of preferential treatment, and that's not outside of the fair housing laws. So again, that gap between where your fair housing laws go over and above what Maryland and the federal laws do, that's the place where you guys are uniquely in charge of that little sliver of the law. So the Maryland Commission on Civil Rights isn't doing enforcement on those much smaller landlords. The good news is that there's probably not a lot of housing that really falls between those two places. The owner occupied 5 units or less, that's not a huge percentage of housing that's out there. So I also want to touch on quickly disability rights in terms of fair housing, because people who have disability have some additional protections, not just the ones we described, but they also have some additional protection, which are called reasonable accommodations and modifications. Modification is going to be a physical change to a housing unit. So putting grab bars in the bathroom, putting a ramp in for wheelchair access or mobility purposes. Accommodations are exceptions that are made to a policy. The most common one we see are people who need service animals for whatever reason. And this is really important because 20% of all Marylanders have one or more disabilities. So this is a much larger percentage of the population than you might be thinking about. And I want to flag that a request for a reasonable accommodation can be made at any time. There's no wrong time that somebody can make that request. So those are broadly, very broadly, like a 1,000,000-foot view, what the fair housing laws are. Who's enforcing these laws? You guys are, we are, so is HUD. So it happens at multiple levels at the same time. Local governments are obviously able to enforce their own fair housing laws, but they may also coordinate with HUD in order to be sort of local enforcers of the federal laws, especially where they overlap with local laws. So in Maryland, our local enforcer with HUD, it's called a FAP, Fair Housing Assistance Program. Our local enforcer is the Maryland Commission on Civil Rights. So they do all of the complaints that come through Maryland, whether you send a complaint to HUD or you send a complaint to MCCR. MCCR is the one who gets all of them, except obviously the ones that are happening at the very local level, at the county level. And then there are private nonprofit organizations like FHAC. Some are HUD funded, some are not. The HUD funded ones are called FIP, Fair Housing Initiatives Program. So we have FIPs and we have FAPs. And once you can keep that straight, you're golden. That's a challenge right there. So we are not a FIP, you guys are not a FAP, and yet we are both fair housing enforcement organizations. So that gives you maybe an idea of the matrix we've got going on here, yeah? Some nods. So what do fair housing enforcers actually do? I know that you guys have gotten, again, into the nitty gritty on this some already, but the big pieces are investigating and evaluating fair housing complaints. When evidence of discrimination is found, taking administrative or legal action. We also want to prevent discrimination through doing compliance trainings with landlords and property owners and housing providers. Every entity that we said was covered, all those folks. And then we do monitoring of compliance with fair housing laws through testing, but also some other systemic analysis, like looking at Home Mortgage Disclosure Act data. That acronym is HMDA. HMDA data tells us who's getting mortgages, where, for how much, at what rates. It lets us really dig in and see whether the banks and other mortgage lenders are discriminating and have big patterns of discrimination. So not one off, but looking at a pattern across the whole market. I wanted to dig in a little bit to those fair housing complaints, because that's such a big part of what fair housing enforcement is about, is addressing those sort of individual complaints that come up. So this is a look at some data from, the data comes from the National Fair Housing Alliance. They're called NAFA, and HUD's Department of Fair Housing and Equal Opportunity, FHEO. But the graphic comes from the National Low Income Housing Coalition, and they get called NLIC. See, this is a whole alphabet soup. You can see sort of a slow but steady rise year over year in fair housing complaints. This chart shows 2000 through 2017, but the numbers continue to creep up in 2018, 2019, reaching an all-time high of 31,202 complaints in 2019. So here's looking at, in 2017, all of the cases that were resolved that year. How did they get resolved? The plurality of cases, 47%, were discrimination unfounded. That does not mean discrimination did not happen. That means discrimination could not be proven legally. It is tough to prove. And so that can be a really challenging thing. And so 47% of cases that were resolved that year, discrimination unfounded. Next up, we have 28% were effectively settled. There was some sort of conciliation, some sort of settlement. They reached an agreement and everybody said, all right, this works for us. Something that keeps me up at night, slightly more than 10% of cases are closed due to administrative error by the local Fair Housing Act enforcement agency. So that's a big chunk of numbers. That's a big chunk of complaints that don't proceed because of mistakes that are made sort of either at my level or at your level. So that really tells me, as we are building our own fair housing enforcement program, I am trying to be very mindful of how to dot all the I's and cross all the T's. I see you guys getting some excellent training, so I know you're doing that too. But I do want to flag that about the need to be very precise and to be very alert to all of that nitty gritty that you guys were going into earlier. The other thing that I see, and I don't think the graph does a great job of showing it, but the total resolved cases here is 8,044. And the total cases that were filed that year were 28,843. That's a big discrepancy. So that's something else that tells us a little bit about fair housing enforcement, right? If the cases, 28 some thousand are being filed every year, but only 8,000 are being resolved every year, it is a complex process. It takes a while. So that's another thing to sort of big picture think about with enforcement in terms of the scale of things. Excuse me. So now we're jumping to a different set of graphics. These come from NAFA, but they are their own data, their own graphics. And this is showing in 2019 all of the complaints that were filed by protected class. So you see just about 60% of complaints are coming from folks who have disabilities and are probably needing reasonable accommodations or modifications. They might also be experiencing other types of discrimination, but the majority of those disability complaints are going to be about needing accommodations and modifications. And then the next largest class by complaint is race. And that's, you guys, my screen where you guys is just blocking exactly that number. 16, a little more than 16% of cases are race. And then from there, it sort of breaks down. That 10.79% of other sort of again goes into that plurality of different kinds of protected classes and the idea that they get smaller, but also they can vary depending on where you are. Of those cases in 2019, in terms of transaction types, far and away the most complaints are about rental housing. And then that 16.25% are other. Here's the graph that breaks down the other. What really strikes me is that this is the other breakdown, and even the other category has its own subcategory of other that is still 9%. So these are somehow types of transactions that still aren't covered under rental or lending or sales or insurance. Like that gives you a sense of like the breadth and scope of fair housing law in terms of who it covers and what kinds of things it covers. This graph is Maryland. So this is from the Maryland Commission on Civil Rights, their 2019 annual report, which just came out. I say just came out in January, like it's still March and January just happened. I guess that was a little while ago now, but this year's been weird and my sense of time is off. So it just came out 10 months ago. And that's a breakdown of the housing complaints in Maryland by protected class that year. They got a total of 93 complaints. These numbers don't add up to 93 because some people are members of multiple protected classes, and in this data, they didn't try to make you claim one or the other. You can see, again, disability far and away is the biggest, followed by race, and then coming up from behind, and this is something that they said they have seen growing since about 2016, we see these retaliation. And if you'll remember when I was going through that long list of all the specific things that are not allowed under the Fair Housing Act, one of them is that retaliation piece, that trying to stop someone from exercising their fair housing rights. It's just interesting to see this begin to spike in Maryland. It came out of nowhere, and it's been rising since 2016. So it's something to keep an eye on, and yeah, it's something to be aware of. I tend to think it speaks to some of the breakdown in polite society that started around 2016, but it's really hard to say for sure. We just don't have enough information.
Robin, could I interrupt you for a moment?
Sure.
Chuck from Arundel TV, I'm hoping you can hear me, but Kaylee asked me to tell you that we're going to need to run over a little bit past the 8 o'clock hour. Chuck, are you there? Hopefully he heard that. And if you can hear me, Chuck, we're going to go till about 8:10, 8:15, I think. All right. Thank you, Robin. Go ahead.
Yeah, absolutely. And I am getting close to done because I know I'm at the end and people are running out of steam. What I'm going to go back. What I find so striking about this data for complaints in Maryland, 93 complaints in a year across the whole state, in a state with a population of 6 million people, when we know that some areas remain hyper segregated. That doesn't seem right to me. When you can look around, and I live in Baltimore City, so I do look around and I'm able to see strong evidence of rampant housing discrimination and rampant segregation, and yet we only see 93 complaints coming through every year. There's a big mismatch that's happening there. And this is where the fair housing education and outreach comes in. Fair housing laws are boring, and they are complicated, and they are inaccessible. They were passed, the Fair Housing Act was passed as sort of the culminating moment of the civil rights movement. These powerful expressions of the necessity of housing for human dignity. We had this huge, powerful moment back in the 60s, and then we took this big idea about equality in housing, and we sort of trapped it inside these very technical terms and legal definitions, and we made it really hard to understand because you guys spent this whole evening sort of parsing through some of that. And that makes it so like everyday folks just can have a hard time knowing what is fair housing, how does it relate to them, and what are they supposed to do if they think that discrimination's happened. And so that's where the fair housing education and outreach comes in. We right now have been, this is the first part of my job, was coming in and putting together a series, 2 series really, of trainings. We have a Know Your Rights selection of trainings. It's presentations, trainings. I can come and do tabling, but a whole Know Your Rights campaign that's just about getting people to know that they do have fair housing rights, what they are, what to do about it if they think they're being discriminated against. We have 2 selections under that catalog right now, Fair Housing 101, which is what it sounds like. And then we have a new law that is both in Anne Arundel County, but now just this month has gone into effect statewide, and that's adding source of income as a protected class. This is really a huge deal. The Housing Choice Voucher Program was started as an intended to deconcentrate poverty. But as long as landlords and property managers are allowed to not accept housing vouchers, the program cannot effectively desegregate property, deconcentrate or desegregate poverty. And this is problematic for fair housing purposes, both because of the socioeconomic of people living in poverty being segregated, but also because there's such a strong correlation in racial wealth disparities and poverty, and the connection to housing and the connection between housing and opportunity. And so it's so problematic to limit people on where they can live based on how they pay their rent. And so now that we have these new laws, we're trying to make sure that everybody knows they have these new rights, and to get this information out far and wide. So we have our Know Your Rights housing vouchers training, and we actually have several public trainings coming up November, I think it's 4th, 5th, and 7th. And when I send Ms. Faye this presentation, I'll make sure I send those links along as well. And then coming soon next year, we'll be having a Know Your Rights training specifically on housing and disability, where we get into accommodations, modifications, what you can ask for, what the definition of reasonable is, and all of digging deep on that. The other training track we have is fair housing compliance, and that's aimed at property managers, landlords, realtors, all of those many types of housing providers and advertisers that we talked about before. This is to help them comply with the law. And we really try to frame it not as like you're bad and you're racist and you're discriminating, but to say it's a complicated law, and we appreciate that you are not an expert in it. So we just want to make sure you know what the common mistakes are and how to fix them. Or, hey, there's a new law about source of income. Here's what you're going to need to do to be able to comply with it. And then again, we have a coming soon training coming next spring that's digging in on, again, accommodations and modifications. What are the rights and responsibilities here, mostly of landlords and property managers? They're the ones going to be most impacted by that. So we are available to do these trainings. For anybody in Anne Arundel County, we want to be reaching out and getting this information out far and wide. So if you guys have ideas about groups who need these trainings, please let me know. I am anxious to be getting this information out to anybody who's interested to hear it, and even some people who aren't. And the last thing I want to touch on is fair housing testing. Fair housing testing is one of the best methodologies we have for building evidence of discrimination. And basically, it's mystery shopping. You send 2 people in undercover to go purchase a house, rent an apartment, whatever kind of fair housing transaction you're trying to test. Insurance can be tested as well. Mostly we do rental testing. But you send somebody in to rent an apartment, and they write a very detailed report about everything that happened, not their opinions about what happened, but objectively, step by step, what happened during every part of their interaction when they went to try and rent that apartment. Then you send in somebody who is almost exactly the same, except they're a member of a protected class. So if you wanted to test race, you'd send in a white 35-year-old woman who has 2 kids and is looking for a 2-bedroom apartment and earns $30,000 a year. And then you send in a black 35-year-old woman who has 1 kid and is looking for a 2-bedroom apartment and earns $37,000 a year. The protected class person is always a little bit more qualified than the non-protected class person to make them sort of the better potential customer to give that, to take out sort of any ambiguity. They both write very detailed reports. They do not talk to each other about what happened. We are trying to be this is a legal process. We are gathering evidence, so there's lots of procedures involved, but we look at the detailed reports they both write, and when we see differences between how they're treated, that becomes our evidence of discrimination. And we are right now launching our fair housing testing program. We are preparing to launch it in the new year. We have a training coming up at the end of November for fair housing testers. It's a contract position, it's paid. Commissioners, none of you are eligible. It's a conflict of interest, but I know that we're being broadcast right now. So anybody who is interested in being a fair housing tester, this is for you. It's a paid position. You even get paid for the training, $150. If you're good, we'll use you all the time. We've got bunches and bunches of tests coming up this next year. We will be doing some fair housing testing in Anne Arundel County in the coming year. I don't want to give too much away because part of the important part of it is that people don't know that they're going to be tested. But our focus is broadly going to be on that source of income, that new protected class, making sure that landlords and property managers are in fact accepting the vouchers that they are legally required to now. And I will leave it there. If you have questions, I am happy to take them. If you'd like to email me, there's my email address. I also have a nifty calendar. You can set up a meeting with me. You just have to click that link. You don't have to email me first or call me first. Just go to that link and I would be happy to talk to you about fair housing. And if you want to report discrimination, get housing help, or apply to be a fair housing tester, that paid contract position I just talked about, where we pay you just to get trained, you're going to go to fairhousingmd.org.
Thank you, Robin. I know we have at least one commissioner that has a question. Mary, go ahead.
Yes, thank you very much. You mentioned your fair housing education and outreach. I want to hold that next to the idea that there are some things enforced at the Anne Arundel County level that are not enforced at the state level. And I'm wondering how we, as the Anne Arundel County Human Relations Commission, could leverage the state's fair housing education and outreach. Roberto, does that make sense?
It does, but I think this is probably something that we should have a discussion about.
Okay,
at
I
another
withdraw
commission
the
meeting.
question.
Yeah. No,
I can
absolutely. I think we should try, but we need to talk about it.
I can say that in the fair housing compliance workshops we do touch on the fact that there are differences in the local jurisdiction, and we are contracted with the Anne Arundel County Housing Department to do some compliance trainings for landlords. So that is something we specifically talk about in those, as well as, if we did specific Anne Arundel County Know Your Rights trainings, we would also talk about the different protected classes. So we would include that in our outreach.
Robin, thank you so much for the presentation. Please send a copy of it to Commissioner Gaskin, and she'll get it to everybody on the commission. I have a feeling that we will be in touch again. I really appreciate you taking the time to present to us tonight.
Yeah, absolutely. Thank you all so much. And thank you for this amazing work that you do. I know that you are, this is something that you are called to, not something that you do because you're getting paid the big bucks. So I just want to say thank you for the work that you all do.
Thank you so much.
I just want to thank you also, Robin. It was very informative. As Roberto said, we'll be reaching out to you again. Thank you so much.
Excellent. Thank you all.
All right. Thank you, Robin. And let's just, we're running over. Let's try to wrap it up as quickly as we can. Just a few, we're moving on to good and welfare, the next section on the agenda, the announcement section. Just want to again welcome Lakeisha Hatcher. Lakeisha, rest assured, this is not a typical meeting. We usually don't have this many presenters, so there'll be other opportunities for you to have lots and lots of discussions with us. Real quickly, I want to note that Commissioner Mohan Grover has decided to step down from the commission. He is going to be submitting his formal resignation in writing in the next few days. I want to publicly thank Commissioner Grover for his service to the commission. You know, he served on the Human Relations Commission since before County Executive Janet Owens, and I can't remember, it was early 2000s when Janet Owen was a county executive. So he's spent many years working with the commission on these important issues, and I just want to acknowledge and thank him for his service. Again, we're running over, so I'm trying to wrap this up as quickly as possible. I know Commissioner Eugene Peterson has a real quick update for us. He's been participating on the hiring panel that's been interviewing the new police chief for the county, and he's been doing that in his capacity as Human Relations Commission police issues liaison, I guess we could call it. Eugene, I'm going to turn it over to you.
Thank you, Roberto. I'll be real quick. I participated in the panel review of the finalists for the police chief position. Other parties involved were the NAACP, the interim chief, Fraternal Order of Police, two councilwomen, Councilwoman Lacey, I believe, and Councilwoman Hare, I guess Republican and Democrat, and let's see, who else did I miss? I think that covers the waterfront. We interviewed 3 finalists, and I was able to present our questions that we had developed and to each of the uh, uh, uh,
Candidates.
persons who were applying for the position, and we had a diversified group of finalists, and now we had discussions, and the county executive was involved, and we turned our recommendations and any other information over to the county executive, and he will make a decision. And I believe he'll make a decision before December because of the pending charter amendments that would take his ability to appoint a police chief away from him without the consent and authority of the council being involved.
Thank you, Commissioner Peterson. I know from a conversation earlier in the day with Commissioner Dodoni that she has something she wanted to share.
Thank you very much. I apologize. Please help me if I've remembered the wrong thing. My notes say that I wanted to make the body aware that the Board of Education continues to work on when to reopen schools in a hybrid mode. That means to bring people into a virtual setting. And at last night's Board of Education meeting, it was decided they will discuss it again at their November 4th meeting. Was that the one I was supposed to remember?
I think that was it. I know I provided the statement that you had drafted and made in your capacity as a member of the NAACP. I shared that with all of the commissioners, and I don't remember what else there was.
And I will do my best to keep you apprised via email between meetings. We are not at this point in that discussion.
Okay. Thank you, Mary.
As a body, I am, as with the NAACP.
Excellent. Is there any other commissioner or member of the commission, including you, Alana, any other announcements that are pressing need to be made? Again, I'm just trying to wrap up our meeting as quickly as we can since we're going over. Anyone?
The only thing that I would just announce very quickly is please, commissioners, do not forget in the month of November, besides our regular monthly meeting, we will have a training session on mediation, conflict resolution, active listening, and de-escalation.
Yep, and that's November 12th. And then we have our regular meeting the following week, November 19th. Okay. Just real briefly, at the last meeting, we talked about voting on a brochure for the Human Relations Commission. I took a look at it and it needed to be redone because basically this was a brochure prepared by the prior commission before the new law went into effect. I've taken a stab at updating it and hope to be circulating a draft to everyone via email in the next few days. And I would look forward to continuing our conversation with the rest of the commission. I believe we'll have some time to do this at the next meeting with respect to the issue of how do we do our outreach, particularly with respect to fair housing issues and letting people know that you can't discriminate in housing in the state of Maryland. And if you do, you have recourse by pursuing a complaint with the County Human Relations Commission. Other thing, commissioners, I'm starting to work on drafting our annual report. If there are recommendations you believe we should consider making, and this is something that we're going to be discussing at our December meeting, please email me so that I could start drafting the relevant portions of the report. I sent a couple of recommendations around, proposed recommendations for your consideration. One regarding recommending the adoption of Smart Policing Act, similar to what Baltimore County recently enacted. And the other one is about creating a standalone committee against hate violence, focusing on dealing with hate crimes and bias incidents. Again, looking for your input. No decisions have been made. These are just things that we're considering. And that is about it in terms of announcements. If no one has any other announcements they'd like to share, just again, please note we have our training meeting on November 12th and our regular monthly meeting on November 19th. Okay. Thank you everyone for coming out tonight. Can I have a motion to adjourn the meeting?
So moved.
Can I have a second?
Seconded.
All in favor?
Aye.
Aye.
Thank you, everyone. We'll adjourn the meeting at 8:16 p.m. We'll be in touch and see you next month. Thank you, everybody, and thank you for your time, attention, and patience and your hard work on the commission. Have a good night.
Take care.
Bye-bye.
Bye.